Yesterday on The Big Picture, we brought it to you as breaking news, but we heard from Governor Mike DeWine for the first time ever in his tenure,
Mm.
publicly stating his stance on the death penalty, which he says
Right.
should
Yeah.
be abolished
Yeah.
in Ohio, which
Which-
he has never said before.
Yeah.
So this was a big deal.
So here's kind of what
Yeah.
he said, and then we'll break down more of really what was an hour-long press conference.
It was long.
In summary, each decade that the death penalty has been in effect, the chances of a murderer getting executed get more and more and more remote. The conclusion I draw from all of this is that it is today impossible to make the case that the death penalty is a deterrent. I no longer believe the death penalty is a deterrent to murder. The moral justification I had for voting for the death penalty simply no longer exists.
And joining us right now, we are bringing in Robert Barnhart. He's an associate professor of law at Capital University with a specialization in criminal law. Rob, thank you so much for joining us today.
Oh, you're welcome.
All right, so we just heard from Governor DeWine when he said yesterday that he believes, quote, the death penalty is not a deterrent to murder. What can you tell us about this statement in terms of law and capital punishment?
Sure. So classically in criminal law, we justify punishing people under four different theories. Deterrence is one of them. Some people believe the purpose of punishment should be retribution or just desserts. You sort of get what you deserve. Other people think the purpose of punishment could be incapacitation, just stopping this person from doing anything else. And then there are finally those who believe the primary purpose of punishment should be rehabilitation. And so what I hear Governor DeWine saying is that his justification for supporting the death penalty has always been deterrence, the belief that it stops either a single person or multiple people from committing the crime of homicide. But given the current state of the death penalty, he doesn't believe that it does deter folks from committing murder. And so therefore, he feels it is no longer morally justified.
Okay.
What that means in terms of, oh, sorry, go ahead.
Oh, no,
Continue.
you can finish there.
What that means in terms of the law, though, in the state of Ohio is frankly not very much. The legislature has been encouraged by the governor to consider abolishing the death penalty. But if they don't, it will remain on the books in Ohio. The governor cannot unilaterally end the death penalty. All the governor could do is commute the sentences of those on death row.
And one point that the governor made was that the average time from conviction to this being carried out is something like 21 years. You have experience working with the death penalty division over at the Ohio Public Defender's Office. Talk to us a little bit about your work there and the understanding of this appeals process, because we know that can be what delays this and continues this on for, as the governor mentioned, an average of 21 years. What does that look like?
Sure. So when somebody is convicted of the death penalty in Ohio, there are two processes they go through. One is their direct appeal. What direct appeal is we're just looking at the record of what happened in the case and seeing if any legal errors were made that justify reversing the conviction. In Ohio, your direct appeal from a death penalty conviction goes directly to the Ohio Supreme Court. You don't take a stop at the local appellate court. So the Ohio Supreme Court directly hears those appeals. At the same time that that's going on, there's a process known as post-conviction petitions in Ohio. What those are a way of attacking a criminal conviction that can utilize evidence outside of the record that was developed at trial. So let's say, for example, I find out there was an alibi witness that the defense attorney never called, or an expert witness the defense attorney never called. I can't challenge that on direct appeal because none of that stuff is in the record. We don't know what that person would have said if they testified. But post-conviction allows me the opportunity to develop an additional record to also attack my conviction. After those are both done in death penalty cases, they then move to the federal courts under the writ of habeas corpus. And in that case, and this is something we did a little bit of at the Ohio Public Defender, but is primarily handled by the federal public defender, the inmate challenges their conviction as violative of their federal constitutional rights. And so they can bring in additional evidence, but that is severely limited because of one of the laws that Governor DeWine referenced in his press conference, which is the Anti-Terrorism and Effective Death Penalty Act, sometimes called EDPA, that severely limits the power of the federal courts to grant a writ of habeas corpus. But you still file it, and then that writ, if it's denied, is appealed to the Intermediate Appellate Court, which would be the Sixth Circuit here in Ohio. And then ultimately, that case could reach the Supreme Court, though there's no appeal of right to the Supreme Court. As we know, the Supreme Court decides what cases it wants to take and what lower court rulings it wants to let stand. That is kind of the basic process. What I'm missing in there is there's also this motion for a new trial that's available in Ohio that could be based on newly discovered evidence suggesting innocence, or at least suggesting a reasonable juror might come to a different conclusion. And so it's all these procedural safeguards that are in place that are essentially what can cause that delay. And then if there is a reversal, that now we got to go back and resentence or retry. And so that could also increase the time.
So after we heard from Governor DeWine officially making his stance on this, and we also heard from the other gubernatorial candidates, Dr. Amy Acton and Vivek Ramaswamy, with their opinions on this, you've worked with the families and you've worked with the victims. How do they feel about this? How do they feel about the death penalty?
I think feelings among victims of crime or families of victims of crime vary widely about the death penalty. We have had cases in Ohio where members of the family show up at sentencing and ask the jury not to sentence death, that they don't want it. Either they don't believe in it, or, they believe in forgiveness. Other folks are very adamant that it is the only justified penalty. And so I think opinions among victims' families vary as widely as they do in the general population.
So Governor DeWine making this announcement yesterday really doesn't have much of a impact technically with the law, right? Is that what you're saying?
It has no impact with the law.
Yeah. So do you think he just made
His
this announcement?
only power would be to grant commutations.
Okay. All right. Well, thank you so much, Rob. We appreciate it.